Доброго дня, шановні учасники.
Good day, dear participants of the conference. It is my pleasure to welcome you here at our event, and currently we have 91 participants. We are starting the second day of the conference, and as of now, there are two interesting sessions. One of them has to do with international taxation, and transferred pricing has become one of the most widespread among our participants who have sent their notes and who will be delivering today. 10 speakers we will hear in this session. I want to tell you that the issue of international taxation and transfer prices is one of the most important points, both in law enforcement and in social relations. And of course, in tax chamber, a lot of attention is dedicated to them. A couple of words about our chamber, that the chamber of the Supreme Court on taxes, about taxes, customs, and other mandatory levies. I have to say that especially our Ukrainian audience knows it very well, and for international experts and representatives of other states and countries, they should know that this chamber today has 17 judges, out of which six judges are doctors habilitas and 9 judges are PhD in law. That is, we have quite powerful representation, judges highly experienced in this. It is over 20 years experience mostly. And also caseload, about caseload you heard yesterday. 55% of all the cases that are filed with the Supreme Court. It should be mentioned that starting this work, the Supreme Court has started working on the 1st December 2017. We in our tax chamber have over 100,000 cases, and for now we have 4,000 cases still remaining to be considered. So you can imagine what kind of caseload these justices have. We also had transfers and secondments after the second stage of competition to the Supreme Court. We know that the fact that Ukraine is on the way to its integration with the European community is also contingent upon the time frames of how long the courts are considering cases. And in chamber, we also have over 800 cases since 2018. I hope that we will have dealt with it. And in any case, it cannot be an impediment to us joining the EU. That is why the chamber is quite consolidated. We work quite intensely, and a lot of attention is dedicated to all those issues that need immediate solution. And we heard about it from the parliamentary committee, from the head of the parliamentary committee, and from the head of the Supreme Court, the president of the Supreme Court, and we are doing everything we can in this regard. I hope that today we will hear some questions that will be of interest to you. And now we go to session 4. It is consideration by courts of taxation about international taxation and transfer prices. Moderator of this session will be our judge, Natalia Blazhevska, Justice of the Supreme Court within Cassation Administrative Court, Dr. Habilitus and Professor. It is my pleasure to give the floor to her. Good day, dear colleagues. Good day, dear Mrs. Hanina. Yesterday, in welcome remarks and opening remarks, we heard that administrative justice is impossible without Mihalis Makovich. And today, on the rights of the moderator, I can also say that without Raisa Hanina, it is impossible to imagine the tax system within the administrative courts in Ukraine. And a small side note on my part, please be reminded that there is a war being waged in our country. And this conference that Raisa has organized, it is the best and good, the most nice feeling that we have had since the war broke out, because for the second day we have this wonderful opportunity of hearing from highly talented speakers, of participating in discussions, and at least have some distractions from the air raid alarms that have blasted our Ukrainian sky. That till the 24th of February was a peaceful one. And then we heard from Raisa Hanova about the statistics. Our chamber has been very consolidated, and that is not by chance, thanks to this huge experience of Raisa Hanova. And we hope that we will never have it again to experience how to live within the war. But we have considered our chamber's cases, and moreover, if Raisa Hanova doesn't object, I will say that in 2014, when Russia first attacked Ukraine, in 2017, it was Raisa Hanova who, the chair of the then Donetsk Court of Appeal, got decorated for the quality of her work. She provided opportunities to the parties, although at that time the country was already at war. They got access to justice. It is our most important task, and we thank for the fact that thanks to these judges, thanks to Raisa Hanova, we have this consolidation in our work. And today we will hear the best speakers. We will hear from the best excellences today, speakers that it will be my displeasure to interrupt. That's why our dear technical support team will say that 5 minutes before the timing is over, please be informed that 5 minutes are remaining. Dear colleagues, we start today's panel with the report of our friend, who we will shortly be presenting for you very interesting and good project. I mean, the fact that we will present it to you at the end of the event. And now the topic that is very important for us. So we will hear from Honorable Thomas Balko on the role of judges in administering justice in transfer prices. And Thomas is the senior counselor on HR for capacity building on BEPS with practices of the Center of Tax Policy and administering of the OECD. Dear Thomas, please, the floor is yours.
Good morning, everybody. I would like to make sure that you can hear me and also that you can see the slides. Is everything okay? Perfect. I would like to thank you for the privilege to be able to join this conference. And I would also like to express my admiration to the organizers and all the participants. I recognize the difficult situation and conditions, and even more, we really appreciate that you took the time and effort to continue work and to continue sharing your knowledge and sharpening your understanding by listening to each other. So please accept my gratitude for the invitation, and I will briefly present my presentation. So in the presentation, I would briefly want to touch on the relevance of transfer pricing rules. And of course, what are the considerations that may be also relevant for judges' considerations of disputes arising from application of transfer pricing rules. Then I will move into the discussion of the international standards, and in particular, what is the main OECD standard on transfer pricing, which is the transfer pricing guidelines. And I will explain the two dual objectives that we see the guidelines should play. And I would then want to focus also on the relevance of the domestic law, which coexists with the international standards, and consider the relevant considerations of implementation of international standards and best practices, including the work that we have been doing together with the Ministry of Finance and the tax administration in Ukraine. I will then conclude with some challenging situations that will arise, and of course that makes us consider, what may be useful for the preparation of the judges to be able to deal with such challenging transfer pricing cases or questions that may arise. So making a step back on the relevance of transfer pricing in the context of transfer pricing. First, I would like to point out that transfer pricing is a neutral concept that simply refers to the determination of prices or transfer prices. In other words, setting of prices for transactions that take place between related parties. The reality is that approximately 60 to 70% of world trade is actually carried out between the members of multinational enterprises. In other words, a large portion of the global value chain happens within the legal entities that belong to the same economic group. And that means that most of these transactions need to be priced and formalized, even though they economically take place inside of the same economic group. Legally, these are separate legal entities. And as you will appreciate, we recognize that the separate legal personality of those entities. And that creates a challenge for everybody, because those transactions need to be legally formalized. And of course, once you formalize it, you need to price such a transaction. And that is what we refer when we say transfer pricing. So it doesn't mean automatically it's something negative. As I said, it's neutral concept. But yes, there could be also situations that could give a rise to concerns. And I will try to talk briefly about why transfer pricing may give rise to concerns and what are the origins or reasons for those concerns. They are connected with the risk that the prices that are so determined may not be always determined with reference to open market conditions. In other words, we may have divergence. And unfortunately, there is a lot of evidence of some taxpayers taking actions to adjust the prices, these transfer prices, in a manner that reduce their tax liability. So it can potentially have significant negative implications for the tax revenues of the affected jurisdiction. Now, the divergences that may arise will not be always intentionally. So there may be also unintentional divergences that may originate from, let's say, wrong approach adopted by the taxpayer, or maybe being negligent in some cases. But there are also a number of cases, and also evidenced by court decisions from different jurisdictions, where we see some intentional motivations of resulting in the shift or movement of profits and base erosion. So we call that base erosion and profit shifting practices, also in transfer pricing area. That will be motivated by the tax avoidant motivation, so shifting the profits to a low tax environment. And it may happen in different ways. One common example that we observe in transfer pricing is fragmentation of business models. In other words, imagine that we are talking about Ukrainian company that will have integrated activities from, let's say, producing particular products, but also selling those products, including looking for international customers. And they can perfectly, in today's world, well, today's world is affected by the situation that we have, but in general, they could as well manage all of these processes and activities from inside of the same legal entity. And for example, the function or activity of sales, the sales activity, will produce costs for the company. So it's a cost center. However, company may decide, okay, let's separate this activity into separate legal entity. So let us set up a trading company or distribution company in another jurisdiction. Now, what was a cost of employing several employees carrying on that function becomes the core activity of the newly created company that needs to be compensated and remunerated. And suddenly, a cost center becomes a profit center, at least from accounting and taxation purposes. And of course, if this trading or distribution company is located in a low tax environment, then it could give rise to profits being transferred to that low cost or low tax jurisdiction. That example would be example of tax planning, especially if the functions actually move to the other jurisdiction. The example of tax avoidance may be that this concept of fragmentation is merely legally exploited. So the activities continue happening in that original company, but there is a legal form established, and that's the company which may perform very limited activities, but trying to allocate the same type of profits that it would have earned if it was performing the full-fledged economic activity. So the other examples of situations giving rise to concerns would be failing to reflect the full economic reality in transactions between related parties. In other words, there may be differences between the actual conduct, what happens from the economic perspective, and what is then documented legally. In other words, the legal form may not reflect the economic reality. Yet another category of situations giving rise to concerns will be structuring of the transactions in a manner that is not consistent with the industry practices. So we may observe that there is a trend or industry practice established, but the taxpayer may actually try to structure it differently. And he can do so legally because nothing prevents him, but especially the divergence from the industry practice could give rise to concerns. And the tax administration may want to understand what are the reasons, what is the motivations for that behavior. Finally, I think the last category of situations giving rise to concern would be transactions which are not having commercial or economic rationale. And they can be evidenced by the fact that one of the parties in a transactions is typically left in a much less favorable outcome. One of them may be having very favorable outcomes. The other one will be suffering the detriment. Typically, well-balanced transactions or situations between independent parties should leave each of the parties reasonably satisfied and happy for them to enter into such a transaction. If you see a significant disbalance, that can actually be an indicator of potential absence of commercial or economic rationale for one of the parties to the transaction. Now, briefly about the international standards. Where are the transfer pricing concepts reflected? And we can find them in Article 9 of the OECD Model Tax Convention. This is Model Convention, but relevant in the context of most of the bilateral tax treaties. And in fact, Ukraine has included Article 9, to my knowledge, in all of its bilateral tax treaties. So that is where we can find a principle that will basically be the core principle for transfer pricing, the arm's length principle reflected. We need to keep in mind the context of the bilateral treaty.
5 minutes.
And that is there to prevent or to resolve double taxation. So there could be interesting questions to consider. How can we resolve double taxation in the absence of the bilateral tax treaty? Because there could be also transactions involving Ukraine and other jurisdictions where no tax treaty has been concluded. Another interesting question that will arise: what if there is no double taxation arising? Even though we have a tax treaty, we have two jurisdictions, but one of the jurisdictions is not levying tax on the transaction. How should we be applying principles of Article 9 in the Convention? Now, the second important consideration will be the relevance of the domestic law. So how does the domestic law interact with these international standards and provisions of Article 9? What is important to keep in mind, the provisions of domestic law effectively give effect to the provisions of Article 9.1. Article 9.1 allows the jurisdiction, such as Ukraine, to increase the tax base of its taxpayer if the arm's length principle is not complied with. If you wouldn't have such provisions, you would not be able to correct the tax base of your Ukrainian taxpayers. But as you know, we have these provisions in place, and they play a significant role in the current activities of the tax administration, and gradually will form a body of case law of your courts. The last comment on this slide is the relevance of the OECD transfer pricing guidelines. As you may be aware, they are being addressed both to the tax administrations, but also to the multinational companies. They evolve over time, but they evolve in an evolutionary manner. So typically changes don't mean a change of concepts or change of understanding. These changes are typically considered to be clarifications to the understanding of how to apply the transfer pricing rules internationally. There could be interesting situations of conflict or difference between the messages or the guidance in the transfer pricing guidelines and the domestic law. And if we see such differences, the question is how to resolve it. My answer to that question would be that typically, if you are making a decision in a judicial case, it will be your domestic law, which will be the primary source of rules and regulations to be applied. It would be very rare instances, in my view, when you would probably take a different approach and then try to instead apply directly the OECD transfer pricing guidelines. The guidelines will play an important role as an interpretation instrument in the context of Article 32 of the Vienna Convention on the Law of Treaties. But to the extent your domestic law provides specific provisions and rules, I would probably see the priority of the domestic law unless there is some obvious conflict that will need to be resolved to give primacy to the international standard. I will probably pause here because I think I'm running out of time. So maybe I'll just show you what else is there. I wanted to talk about a dual objective of the transfer pricing guidelines, which is to make sure that countries in the first place get the appropriate tax base. And the second objective is to avoid or prevent double taxation. Important work to be still done in implementing the international standards in Ukraine. The items in bold still require additional legislative actions to fully align your domestic law to the international standards and recommendations. And I look forward to continue working with the Ministry of Finance and Tax Administration in this process. Additional considerations are also highlighted in this next slide. And also we have the area of attribution of profits to permanent establishments, which is a topic very closely related to transfer pricing because we use the similar rules and principles. Finally, there is a slide with a lot of considerations especially for judges and relevance of this context in the context of resolving the disputes in the courts, but I would probably reserve it for other opportunity, not to take time from other speakers. So thank you very much for the invitation, and I look forward to be in touch and meet you on a future occasion.
Томасе, ми неймовірно вдячні
Thank
вам.
you, Thomas. We are extremely grateful to you for the contribution you made to our tax system, providing your advice and this presentation today, where you drew our attention to the effective international standards. As the moderator, I would like to say that the case law of our Supreme Court, and perhaps you well versed in it, also has references to the commentaries OEC for so that the international practice is reflected in our case law as well. Case law is in compliance with it, and we have the legal certainty for the taxpayers in this field. This is very important. I would like to draw the curtain aside a little bit to unveil this thing that we have to present to you with Thomas. It is a project. Reis and myself, we wanted it to start before the conference, but the war made its impact. So it remains till further notice, and you have to stay in the trend of the international standards. Now, let's switch to our next speaker. And I have the great pleasure to introduce him. Our joint publication, I must say, is already available with the collection of works prepared by Reisa for this conference, and all our committee members were the contributors, candidate of economic science, Leiden University graduates, Erasmus Notre Dame University. Some presumptions in dispute resolution and methodology on transfer pricing. Alexei Shmatko, the floor is yours. Good morning, dear colleagues. I'm happy to talk to you and have this opportunity to present an interesting topic and a novelty to some extent, because I always try to analyze the case law, the jurisprudence, when it is mature enough, identifying some doctrinal signs for application of certain provisions of the legislation. And here's the question: when in the case law, I can outline some doctrine for the transfer pricing methodology disputes. And I would like to speak as a follow-up to Thomas's presentation, because the guidelines, serve as a very important manual methodologically, but they fail to set any kind of specific procedures. The levying of taxes, the mechanism is provided for by the tax code law exclusively. Article 39 with us is a reflection of the OEC transfer pricing guidelines, but if the guidelines are reflected in the methodological language, they do not set any priority, any presumptions, the range to be calculated, or the technique to be picked. There is some set of priorities and the prevalence of some methodological considerations over others. And where there's this resolution for transfer pricing, they're guided by the tax code norms, having the OSC norms. This is the choice of methods, the qualification of transactions. There are some disputes on administering the control transactions, the business goal concept, and proportion of the national and international rules. I understand from your agenda that you will also highlight such issues in the subsequent presentations. So about the methodology of transfer pricing, this is all explained in the terms that can be subjectively interpreted. The method of transfer pricing is used as the most feasible, and the criteria are feasibility of the technique, the complete and reliable information, the relevance, the degree of relevance, and one out of 7 indicators for profitability and the set of factors. And also we pick up the side that is being examined. And when we choose the examined party, we use the most reliable techniques with the most relevant transactions and so forth. We have this whole pile of judgmental considerations which the judge as applying the law can pick up. And the problem practically is with this Article 77 clause 2, the regulator should prove the legality of a decision. But when we look into the merits and the evidence, this is a very adversarial stage, because every party, every arm presenting their evidence and their merits would probably use the methodological grounds. Each of them is very subjective in its own right. Fortunately, in the tax code, we have certain norms, and with the systemic application of those norms, we can structure this examination process for the merits of the case and evidence. This is about imperative or presumptive character. What is imperatives or priorities? Imperative rules to apply certain sources or methods for certain transactions. Before the 23rd of May 2020, we had the merchandise which quoted at the exchange with the uncontrolled price technique and the sources identified by the cabinet of ministers. Starting from the 21st of January 2023, we'll use the raw material commodities under Article 39. We have the priority for the comparative and controlled prices when it is applicable. And we also have the relative priority for resale and plus the overhead. So the uncontrolled price is the absolute priority because it's formulated in such a way that when it is possible to apply it, it should be applied. So the highest feasibility or the highest degree of feasibility under the code for the comparative uncontrolled price or pricing. If it is applicable in principle, it should be applied. With the resale price and expenditures plus, according to the code, if it can be reliable versus net profit or profit distribution, it should be applied again. So first of all, we have to arrive at the same reliability, the point on reliability, and then use the techniques in question. There are presumptive or presumption methods for the justifiability of methods applied. Why I call it a presumption? Unlike priority, when we have prevalence one over the other, the regulator with presumption has the right and the means to prove that the source of information was the most feasible one, that the regulator has the burden of proof resting on their shoulders. And that refers to clause 270, Article 77, when the regulator has to prove the legality of the decision made. In particular, if the taxpayer, in order to set the compliance for the arm's length, the regulator uses the same sources of information unless it is proved that the relevance is higher with other sources, any other sources. So this is the lever of evidence. And if we use the technique in compliance with this article, the regulator is based on the same transfer pricing techniques, unless the taxpayer, it can be proved that the taxpayer's method is not the most reliable, and the burden of proof is again on the side of the regulator. Now about the case law. That was the codes provisions, and now some jurisprudence. There are two blocks, priorities and presumptions, respectively. So for the sources of information, we have this interesting situation. What it makes it interesting is that the legislation would dynamically change and the jurisprudence would follow. So the dynamic is correlated with the changes in the legislation, follows it. The jurisprudence does follow the legislation. The 24th of February 2020, angelic trade, this is transfer pricing for 2013, and the provisions of the tax code pointed out the cabinet ministers was to set this checklist of sources of information to be used with preference, and the law set priorities, priority for the cabinet ministers checklist. So if a taxpayer for some reason would like to apply any other source of information which is not on the checklist, then the taxpayer have to prove that it can be done feasibly, because there's a better degree of relevance. Starting from the 1st of January 2015, the regulation, Article 39, changed, and with the introduction of the provisions that we have currently, the priority of the taxpayer's preferable source of information, and the court decision in Tradex 2021 for the period of 2015 says that because of the exclusion, removal of the provision for any source of information available for use. If the taxpayer uses the technique, the regulator has to use the same technique or justify, and the controlling body did not justify why or explain why they wanted to use another source of information, why the regulator think that the use of reference books or directories is of higher priority than the exchange quotations in this case. So we have it in the case law. We have this presumption of the choice of technique, and it is also reflected in the tax code. Now about the presumption for the choice of source of information. That was it. Now the choice of technique, well, the regulator does not change it so often. And the grain expert, for example, when the dispute is over, the regulator not liking the source of information used by the taxpayer. But for the change of technique, we have fewer cases. So in 2021, we have another interesting case, TCVK case, because on the one hand, the technique was changed by the regulator, and within its limits, they used another methodological set of parameters. They disagreed with the sample of the referential companies, companies for reference, and there were a lot of methodological issues. So both parties, the claimants and the respondents had no material to justify their position. The point was the taxpayer used the expenditures plus technique, and the net profits method was used by the regulator. So if we look on it as methodologists and economists, not as lawyers, then the stance of the regulator seems more justifiable, because expenditures plus is a technique with, according to whose description, it is not relevant, because that was a tourist operator buying the product and reselling it. So that was the acquisition, and expenditure plus is applicable for sales. But one of the positions for the choice of technique expressed by the Supreme Court is practically in the fact that the taxpayer chose the expenditure plus method. The regulator in this case had to first prove that it was impossible to apply the expenditure plus method with the other parameters. For example, to change the examined party or examined aspect, or the profitability aspect or factor. So they failed to comply with Article 77, Clause 2, and they could not prove why the technique applied by the taxpayer in that case, presumably legitimate, had to be changed for another one, another technique. So summarizing, let me just say for the algorithm presumption being or not being applicable in particular cases, let's discuss the justifiability of the source of information for the imperative rules of priority or presumption in this case. And secondly, to identify the propriety of technique being applied, priority versus presumption, then the methodological parameters within some technique. Why the source of information rights supreme? Because we have to observe the available sources. If we do not do that, we cannot choose the technique in a competent, justifiable, relevant fashion, informed fashion, most important. But thank you very much for your attention.
Вашу доповідь, і я думаю, колеги зі мною погодяться, що поділяємо вашу думку в тому,
I think that our colleagues would all agree, Alexei.
На практиці цей принцип змагальності.
And here we feel this adversary principle even at the stage of cassation, where, as a rule, the parties have less active manifestation of positions. And in this category of cases, I have to say that both the taxation authority and the taxpayer always shows the highest standards of both reasoning. And these cases are very interesting. And this application in practice, we can feel it. Also, we share your views about quite a lot of vague legal concepts subject to assessments, and this gives us an opportunity to hear the best arguments from the parties. And you mentioned dubio pro tribunale. I must say here that Tax Code of Ukraine for our foreign colleagues, as of from the very outset, it has this principle of pro tributario. I cannot say that we use it in every case, but there are a number of interesting cases where we can see that the position of the taxpayer was based on this principle. I know that our Polish colleagues have introduced it quite recently, and our tax code has shown the highest standards from the very beginning. And when we were making up our list of interventions, we tried to have it in such a way as to cover all the most important issues. And now it is my greatest pleasure to give the floor to our next speaker, Maria Carmelita, who is acting head of the Scientific and Research Institute of Financial Policy of the State Tax University, Dr. Habilitas and professor, and this is a very relevant topic that she will speak about. It's ethics in procedure of preliminary agreeing on transfer prices in light of OECD recommendations and guidelines. As our international colleagues see, we make our best to have proper application of OECD guidelines. Dear Maria, please, the floor is yours. Thank you. Dear participants, dear attendees, it is my pleasure to be here and to have you here at our 5th Administrative Justice Conference, Challenges and Practices. The event that has united all the representatives of respective lawmakers, law enforcement, and international experts. European has been looking forward to seeing you, but the war prevented it from having it possible. It is my greatest gratitude to be here as a speaker, so let's go straight to the presentation. In order to meet the requirements of transfer prices, it requires a lot of resources, both from the overseeing authority and from the taxpayer. In this sphere, we have an important issue of APA using English abbreviation, the due use of which will contribute to meeting such goals. Next one. So it is an important factor to have it as more transparent for further operations. And on the principles of tax transparency and to have it as foreseeability, it has been on numerous accounts highlighted at our event yesterday and today. So when having this transfer prices, it is an important point to take into account. Also, it's supporting partner dialogue of the overseeing authority and the taxpayer on the most challenging issues of transfer pricing. Another favorable point is to prevent costs and too lengthy procedures that have to do with difficult issues in transfer pricing. And also it's making the upgrade in terms of skills and deepening the knowledge and having the staff have more knowledge about transfer prices of specific sectors of the economy. Preliminary such an agreement, APA has started drawing attention from the researchers starting 1990s and having positive practices, and also we see that there was lack of transparency and foreseeability in terms of global campaign on preventing BEPS has accumulated the need not only to shape the basic points of APA in Ukraine, but also it's not the first year that we have seen that this is the trend on improving the regulations in terms of the ones that have been shaped in the tax code. We know that later was Japan that used it a lot of years back, and now it's used in Australia, Italy, Canada, the United Kingdom, Slovenia, and other countries. A number of countries have a lot of experience in proper consideration of the applications of the taxpayers, and information for 2019 shows that an absolute leader is Belgium, that has 827 of such contracts. Also, we had with Australia 117, Australia, and the Czech Republic. Respective numbers can be seen on the screen. Moreover, EU member states enter into such agreements and conclude such treaties with other EU members. And we see that there was over 1,000 TPA concluded, and between other countries than EU, they had almost 600 APAs. It is allowed to have all types of contracts, but there are some countries that to some extent limited this choice. In particular, in Estonia, it is possible to have bilateral APAs on procedure of bilateral and concurring. In Germany, it's possible to have multilateral, and unilateral is only possible as an exemption. And in Ireland, it is possible to have bilateral APAs. And in some countries, such as the US, it is possible to have unilateral and bilateral APAs. You have already seen in the tax code that it is defined the general fundamental basics of concluding APAs. It is quite long and challenging process, yet the importance of tax certainty pays off, even if it is too lengthy in drafting. As of July 2015, we have the basics for functioning of APA between the overseeing authorities and the taxpayers. For now, we have this in Article 39 of the Tax Code of Ukraine, and also in the regulations on transactions subject to overseeing that can have unilateral, bilateral, and multilateral nature. We know that at the end of 2021, can you hear me, dear Natalia? Yes, we can hear you. Thank you, because I have unstable internet connection. So at the end of 2021, there were some changes made into the regulations of APA, and we see that it has been improved, not to a great extent, but to a certain extent. And we can expect in Ukraine that there will be concluded from 10 to 20 APAs, and although in global practice of such functioning of the authorities, there is a well-known principle that taxes are not agreed on, yet the procedures of such APA is a perspective tool for governing respective types of legal relations. Now we will go to the next slide about the main trains of the APA. We know after having analyzed successful best practices in foreign countries that it has to do with bilateral or multilateral APAs, unlike the unilateral ones. And we know that there is a tendency is improving of drawing up such APAs. It has to do with bilateral and multilateral APAs. Neither norms of the procedure that I have mentioned provide for only indicate that there is unilateral, bilateral, and multilateral APAs, but the hierarchy of APAs is not mentioned. At the same time, OECD experts recommend that in view of the fact that there is a risk of double taxation, I can quote, it is recommended that where it is important, APA ought to be concluded on bilateral or multilateral basis with competent authorities through mutual agreement under respective international treaty. Bilateral APAs has less risks in part of being forced to conclude an APA or to accept agreements that do not meet such a principle. In order to prevent such challenges, it has to do with possible fines. Bilateral APAs also significantly reduce any challenges in taxation, tax avoidance in general, or falling under double taxation. An example of countries that do not provide for taxpayers a chance to have a unilateral APA is Denmark, Ireland, and Sweden. Another trend is broadening the scope of entities that can go through APA procedure. This tendency is an intrinsic one for Ukraine, because we see that according to Article 39 of the Tax Code of Ukraine, only big taxpayers have the right to go to the authority about having preliminary APA procedure. And this prevents initiating a procedure for persons who do the controlled procedures and who ensure the arm's length principle, and it has to do with big taxpayers. Another trend is the right to extend the coverage by the APA to tax periods before signing the agreement, but not later than when the claim to have it in place was submitted. Also, as an option, we can have a payment depending on overall turnover of the taxpayer. Another trend is prolongation, when a treaty can be prolonged to a time possible. And that's how the parties can prolong it. To that end, they need to provide respective application. We see that in the tax code and in the regulations, there is some points about the APA null and void and termination. It is important factors that are delineated. They should not be confused. In the following slides, I will ask now the technical support to show those slides to us. So here we can see at the example of 3 countries, the structure and the procedure for APA. And in this, we can have participants. Now you can have parties. You can see this procedure that are determined in the legislation of Australia, the United Kingdom, and the USA. And here we can have some other preliminary steps. We can see that there can be preliminary meetings, or there can be in such legal frameworks defined the conditions for such meetings to be held. And then here we can see the process itself of entering into APA based on the application made and signing. It's mostly technicalities, but these technicalities are important in order to meet the best possible conclusion. And next situation at the next slide, we will see here direct entering into agreement and overseeing of such an agreement. We know that the taxpayer must mandatorily report on meeting the requirements of the APA. And now we'll have a look at the next one. So here, please, another point to be noted, we can speak of prolongation of the APA and termination of the APA. In some countries, such prolongation is not provided for by the legislation. And another point is when we have the quashing of such an agreement, it is possible to have it in place. Thank you so much again for a chance to be here, and I wish you all a peaceful sky and good health. And we are always ready to go forward together because we are strength together. Thank you, dear Maria, for such an in-depth and comparative analysis of the use and functioning of the APA procedure in different countries. I have no doubts whatsoever that after getting your presentation, the participants will be able to have even more information. And at international events having to do with transfer pricing, we, the Ukrainian judges, can say that in other countries, indeed, there are not many cases land in higher instances, evidently because of active functioning of the APA. So thank you so much, and it is my pleasure to introduce the next speaker to you, who will present the challenges of enforcing transfer pricing rules with due regard to the tax legislation in 2020. We will hear an overview of such from the first person we will hear, because Roman is Senior Project Manager of the Office of Supporting the Reforms under the Minister of Finance of Ukraine, member of the Expert Council on Drafting Generalized Consultations under the Ministry of Finance of Ukraine. Apart from it, please, can you let us in on the secret of what is to be expected? The point that you are working now, what are the tax consultations? And the floor is yours.
Дуже дякую, обов'язково.
Thank you very much, Natalia. I will try to answer the questions by all means. Let me share my presentation. I hope you can see it. Yes, we can. So first of all, I would like to thank the organizers, the sponsors of this conference, for the opportunity to present our joint work at the venue of the Ministry of Finance, where we have the expert council, the expert board, such consultations. I remember, Natalia, your presentation in our task force working group to discuss the raw materials and goods, the stance of the Ministry of Finance on the legislation. I understand that the transfer pricing issue is not something that arrives at the door of the judges immediately when this issue is established. The stance should be also established, even if a couple of years later, after the fact, the experts provided their opinions duly, and basically, well, let me just check. And the expert board is a standing body under the Ministry of Finance, was created in 2017. And we had two periods at the board, one till the end of 2019, and then starting from December 2020, when practically we had that issue of explaining the changes to the legislation, introduction of the amendments for the BEPS plan. And so we have to discuss law 466, which was adopted to amend this 767 in summer 2020. And the expert board members committed themselves to this responsibility to provide explanations, interpretations of the complicated provisions, so the provisions that proved to be complicated. Well, in advance, let me just say that we did not identify any critical problems in the provisions in questions. The legislation adopted was prepared in a very qualified fashion and set the rules of the game for the transfer pricing and explained everything away in the best possible way. In December 2020, we renewed our deliberations. We created 4 working subgroups, and for the period from the 3rd of December, or December 2020, January 2022, that was the period, 12 meetings, time investment, more than 1,000 hours, and we managed to adopt over that fairly short period of time, 6 consultations, 7 of which to some degree had to do with transfer pricing. I would like to remind you that the tax consultations language can be found at the side of the Ministry of Finance and performing our institutional functions as a policymaker for financial policy. The ministry used the provision of the tax codes to analyze the circumstances point to the ambiguity of the language. The new legislation raised many eyebrows among the taxpayers, and the Ministry of Finance made a very correct step indeed and formed the stance and presented a stance which was much better than to explain it after the fact, which is the right approach. All the consultations to be discussed are to be found at the site of the Ministry of Finance. Use the reference in my presentation, please. In this slide, you can see the 7 consultations having to do in some degree with transfer pricing, and this is a relative and simplified abstract on the number of issues, but it presents the substantiality, the essence of our work, because we expanded the scope with our explanations. We started with the premise that the taxpayer was entitled to full information. We equipped that with the illustrations, the case studies, the experts working on complicated issues like consolidated dividends, the necessity to present some patterns. Sorry for interrupting your speech. Are you supposed to present some slides? We just see the title slide and you're not sharing. It's up to you to share the slides now. Well, what a shame. Can we stop the streaming for a sec so that I rearrange? Can you see my presentation? Yes, you are flipping the slides now. Oh, sorry, it was my bad. The standing body, 16 consultations, 7 having to do with the transfer pricing, time invested, 1,000 hours that I was referring to over this period, and the information where we can find consultations. Well, here in this slide, I try to present a list of consultations reflecting upon transfer pricing, and every consultation from one to several issues depending on the complexity of the matter, and the consultants that were working on those products, they equipped their findings with the case studies and sometimes the illustrating patterns or charts for the reader to be guided and through the reading process. So the first consultation, which we had in January 2021, and the value of this consultation at that time, I would like to remind you, the law 466 came into force mid-May, or it was late in coming, so we had problems with the criteria of recognizing transactions as controlled from 20 to 25%. The ownership share changed, and for which period we had to apply such provisions for the controlled transactions recognition, and we had explanations in much detail on the period of that kind of transaction. So I'd like to say here that this consultation is a model of some explanatory materials and auxiliary material to explain the control transactions as a notion. And that started with a point for taxpayers, their obligation. So the next consultation was dedicated to changes that took place in other matters for the law 466 with the raw material goods changing to the transactions with low taxation jurisdictions and explanations for the new provisions. And another very important element in that consultation, the experts came to the conclusion on the necessity to refer to the guidelines of OECD on transfer pricing for the multinationals and its tax authorities as a document, as a model document for the issues which are not directly interpreted or explained in any other documents. For the issues which are not directly reflected in the tax legislation. Let me remind you that since that time we've had a new version of transfer pricing guidelines 2022 with the amendments, the new provisions on transactions with the financial assets, non-tangible assets, but again, this is the stance of the Ministry of Finance, which is unwavering for the issues which are not directly regulated by the tax legislation. Now, this is an auxiliary document for your analysis, which can be recommended guidelines of OECD. Now, another consultation. We had several adopted in August 2021. Practically, we reviewed the issues of new sharing and international companies and constructive dividends. In such consultations, we provided practical recommendations for compliance with the notifications for the scope of income, consolidated income, to decide whether this particular taxpayer can be recognized as an international one. So this might be very useful for the users of this presentation of the law 466 and explanations of the notifications provided and the algorithm for the taxpayers for the consolidated income and as a logical step further down the road, we had the newsletter for the experts, the tax authorities newsletter with the detail filling out in the form. Another super important consultation we are very proud of is taxation for constructive dividends, secondary corrections. The complexity of the issue is in the problem being at the juncture of transfer pricing and the non-resident income tax. And we provided explanation as to secondary corrections and the rules is set for this kind of taxation or tax instrument, tax to the terms of payment, the timelines of the 30th of September 2022. That was the deadline for the non-resident income tax to be paid, allowed for the secondary correction from the 1st of January 2021. And we provided for the tax base explanation and definition, the detail in which the situation with the dividends identified as the subject taxation, the tax base used for the secondary corrections. And we provided explanations for the filling in the forms, the calculation of the secondary correction amount, and we provided in much detail the explanations on the accommodation with the international contractual rules applied, and we are very proud and rightly so. We provided the patterns, the international contracts where we should use specific rates and which kind of income is eligible when the transaction falls under regulation of an international dual taxation contract. The royalty, the percent, the interest taxed, and the tax control for the constructive dividends, and at which points we could check that for transfer pricing, and when we could let the taxpayer for the company tax. And another consultation I would like to discuss here is the business goal and reasonable economic objective. Without Thomas, without Alexei Shmitko, it would have been impossible to have such a high quality consultation. We are very thankful to the colleagues for their contribution. Answering your question, our plans for the future. Unfortunately, the war started on the 24th of February. We were concluding the newsletter on that same date for the non-residential offices. We didn't issue it for obvious reason. I hope to continue with this after the victory. Now we are working at the menu of the Ministry of Finance with the general consultations, the changes to the tax legislation to clarify the transfer pricing arrangements, conceptual changes, and the concept in particular for taxation for the services with low added value. And there we have the request from the taxpayers in Ukraine, and we would like to respond to them after the victory. The work is ongoing, and we are doing our thing. We're doing our duty to provide for the best interests of Ukraine. Thank you, Roman. We are very grateful to you for this discussion of your work at the Ministry of Finance. And it is very important that before the preparation of these consultations, for the consultations, you invite welcome contribution, the best available experts. We'll be looking forward to your newsletters and tax consultations. Now we have to switch to another great speaker, a judge of Cherkasy Circuit Court, Administrative Court, candidate of law, senior lecturer, and senior researcher, trainer, coach of National School of Judges, Larissa Trofimova, who will discuss the BEPS plan as guidance and as equilibrium tool. Now, thank you very much for your invitation, for the opportunity to participate in this very important discussion. Can we open these slides? I wonder. Well, thank you. I'd like to say here that the topic that's discussed, speaking of the interest of the state of Ukraine at this particular stage, when we have the martial law in effect, many reforms. Next slide, please. I still remember Mykola Kucheriavenko's presentation yesterday. He was very emotional in his message that tax law wasn't a mandatory subject for the higher educational institution. And this is a sensitive issue for the educational reform. Let's hope that the administrative reform measures when we do our financial policy making, that will be taken into account, not just with the requests coming from academics and researchers, but also practitioners who presented today, who presented yesterday, and they announced that it was a really interesting action plan designed there with the state sovereignty of Ukraine to be supported directly. And we have to be very authoritative as the judicial system, very competent. This is not just about high quality adjudication, but also the judges intend the Article 50 of the Declaration, the discretion of judges and impartiality of judges, the high profile. Now, the BEPS plan was topical for a long time.
And even the All Ukrainian Association of Judges starting 2015, 2016 on tax advisors have held a lot of events in order to bring across the matter of transferred pricing to a wider audience. And also it had to do with model conventions and comments. It's important to bear in mind that Article 121 of the Constitution deals with the fact that administrative judges are created in order to protect the rights, freedom, and interests of persons in public domain. You know and share the opinion of that the tax relations are in its nature quite conflicting ones, because the share of profit that a taxpayer has made and gives to the country is determined, yet the ways of making money are different, and the use of such manner that will be used in such order on tax policy are being explored when dealing with cases and considering them, and it depends on the activity of this or that entity. And here it must be only mentioned that there are such trends in these 15 steps about this minimum standards. If possible, we can go to the next slide now, that need to be taken into account, not only when considering cases, but when understanding the reality of where the country is, what are the interests of bona fide or good faith taxpayer, and if the taxpayer is not a bona fide one, they risk being brought to respective types of responsibility. I will a little bit later cover how we tie it and what ways, what are the extra ways to be used. And here it must be mentioned that in the BEPS action plan, it also has to do with undue use of benefits under contracts and treaties and agreements, and many speakers have dedicated attention to that. So now we'll go to the next slide. When we speak of such undue use of favors, it must be introduced into responsibility in terms of assessing the tax offense, and it must be mentioned that Ukraine, you know that our association agreement was signed, and up to the end of 2022, we will be under the thorough overview and supervision at the membership steps. It must be mentioned that the BEPS plan had introduced step-by-step introduction into the national legislation. And we heard about MLIs And we need to be mindful of these principles as well. Remembering step 14 and step 15 of the BEPS, it should be reminded that multilateral convention on taxation in order to prevent BEPS has measures that we can take into account. If we know that over 60 or 70 agreements we have, some of them were introduced even at the time of the USSR. Now, during reforms and this action plan, we speak of clarifications of the preambles and balancing. When we speak of balancing interests, we can remember the principle of proportionality in terms of the Code on Administrative Justice, but when we speak of administering the interests of states in these tax conflicts and the bodies of different states also are involved in that. It's another pillar of how to improve the case consideration. And it should be taken into account the understanding of such balance of interests. And I want to quote Danila Hetmantsev, who yesterday was delivering an intervention on the measures on anti-BEPS reform. He said that about the balance of interests, it has to do with policies of the socially oriented state and the big business. Raisa mentioned that it also has to do with small and medium-sized business on simplifying taxation and specifics during the martial law. We can use many of these criteria, but we cannot but remember about the aspects that judges take into account when using judicial doctrines. Another slide has to do with different doctrines, doctrine of the business purpose, or different reality of a transaction, and that is a cyclical circle of connection between theory and practice. And theory issues we can see in different scientists from Ukraine, for Vita Leonidovna, about planning and Ukrainian experience, where it was proved that the BEPS and automatic exchange of information, you remember about the order of 2016, when it had to do with the creation of the working groups and automatic exchange of tax information between the countries, you know, information about banks in the Switzerland and openness of such aspects. Therefore, please use such scientific research matters that use respective doctrines like business purpose, content over form, the factuality of a transaction, and now we'll go further. I would also like to mention another point that has to do with the fact that the law of Ukraine on accounting says of prevalence of content over form, and this doctrine was covered by the US Supreme Court in 1935. Yesterday, we heard from Yevhen Smychok, who delivered a very interesting intervention, but in his research, the shaping of due economic reason is the first institution to introduce it was the judiciary, and there is a number of cases where it is utilized. You know how often the tax code is being amended for us, and we know about the due reason and about the tax benefits. It's Article 103 of the tax code. We can skip 2 slides, and the next one will have to do with fair court. Here we'll be speaking of the doctrine of case jurisdiction case when judges, when considering cases, are bound to take into account the interpretations set forth in case law by the higher courts. And Article 13 of the law of Ukraine and the judiciary and the status of judges imposes this obligation on the respective authorities. Natalia mentioned the quality of the administering justice with the example of the biggest titans of our judiciary, and I want to mention about the conclusions and opinions of the Advisory Council of European Judges. And you can have a look at opinion number 11 of 2008. I would quote that in order for the judgment to be delivered, not only due legal framework must be taken into account, but also non-legal reality and lay of land, ethical, economic, and social consideration that demand that a judge take them into account when administering justice. And here we can prove by examples how, while searching for the truth, different methods of dealing with foreign element cases and how the Supreme Court directs us in order to take into account the disputed relations. And you can remember Article 2005 of the Criminal Code that has to do with the impact on actual and not actual transactions or fake ones. And here we have criminal jurisdiction that has to do with the condemnation of a party that doesn't act in good faith. And in this context, the Supreme Court gave its own interpretation of beneficiary, owner of the profits that we can use. In general, having analyzed the Unified State Register, I found a reference on to BEPS in 2 cases, and there is an opinion of the Supreme Court that pinpointed the fact of what the lower court instances have not looked into when opening the proceedings anew. Also, we need to remember about the deadlines, about the costs. That's why the quality of administering justice is of paramount importance here. Please be recommended. Maybe you have seen the overview by the OECD. There are examples of wins made by other tax authorities in terms of transfer prices. I guess we remember how the pricing and control over pricing are done by given to the tax authority. There is 39 and 39 bis points being introduced. We must keep an eye on it. And as a proposal, the next slide is to give a rethink. And we heard from Tax University. We know how much the National School of Judges is working. These people who are involved in education, sometimes we don't have the tax law, but we have financial law And sometimes tax law is there, but we must fill them with quality materials. We must upgrade and update them as necessary and when required. And we must remember that the effective use of these principles are more than important. We need to apply step by step the Code of Administrative Justice, and this will contribute to taking into account Article number 3 of the Constitution during the martial law, when it has to do with the life of people, with the dignity and the role of court in this protection. That is why there is nothing impossible here. It all depends on our will and on our conscience. Now we'll go to the next slide. Instead of finalizing my intervention, of course, I thank you for your kind attention, but I can also say that in the guidelines and in some poetry we have that we do not need words. We only have actions. I wish everyone our victory, everyday one, and a long-awaited one. Thank you so much. Thank you, dear Larissa, for your brilliant address, and thank you for mentioning our first reflections in 2013. Having this event, we even thought, can a court without experts consider these cases? We can see from the practice it is possible. Our judges are working all the time to improve their skills. They delve into foreign research and foreign studies, and we use best practices. And we did use the guidelines of OECD. Our Italian colleagues were before us. We were in the first, but we have more cases that are considered. Now we will go to the next topic. Yesterday, Mihalis Markovich covered very important points in his presentation about the challenges in administrative justice. He covered these important points, principle of independence of the parties, and now we are going to have a fundamental look into it by our foreign colleague, Judge of the Federal Financial Court of Germany, Robert Hübner. We will hear on the principle of independence of parties that is to be met. Dear Robert, the floor is yours.
Thank you very much. Can you hear me? Can you hear me?
Yes, yes, it's good.
It's all right. Okay. Thank you very much. Dear Mr. President, dear colleagues, I am very happy to be invited to speak in this conference. And first of all, let me express my deepest respect and gratitude for Ukraine and the Ukrainian people to fight for a free Ukraine and for a free Europe. Topic of my presentation: compliance of the taxpayer with the principle of independence of parties. Talking about independence of parties is a lot of wishful thinking. Independence presupposes real economic, personal, and moral independence. If there is no real independence, legal independence is worthless. We could fill a whole conference on this subject. Here we focus on the subtle kind of dependence, which can be seen in cross-border contracts between parties close to each other. We just heard other presentations dealing thoroughly with a habit called base erosion and profit shifting. So it is not necessary, it is useless to say a lot about the problem itself. I rather try to give an extreme short view on the German approach to this problem, Germany being a high tax country. If the law of double taxation allocates the right of taxation to us, we have to consider whether contractual network and especially prices may be accepted for tax purposes. We only accept conditions which comply with the arm's length principle. That is, if these conditions would be usual for third parties as well. A small look at the question, do parties comply? Well, they are not obliged to use arm's length conditions. This is essential for our approach. They can do what they want, and they do. However, they must accept taxation which does not exactly comply with their wishes. We do have special legislative rules on testing contracts for compatibility with the arm's length principle. The foreign tax law, it's a known code, contains some fundamental rules on taxation in cross-border cases. The basic rule of the foreign tax law says very briefly that we have to look at the business transaction with a person close to the taxpayer, and we have to check if third parties would not have chosen certain conditions, these conditions are not accepted for taxation purpose. Then correction of income takes place. This is completed by many, really many other definitions and specifications trying to fix as precisely as possible how to find out the conditions which comply or do not comply with the arm's length principle. The principal method for this is the comparison with real or fictitious contracts between unrelated third parties. The comparison method is regulated very much in detail. I have to skip this, of course. And this is not everything. The foreign tax law has entitled the Federal Ministry of Finance to regulate further details, and so they did. By the way, a personal remark, they can regulate as much as they want. They will not succeed to regulate everything, I suppose. In addition, we have special rules how to obtain all information necessary. The administrative procedure in tax matters in general is regulated in a specially created law, the tax code. In general, if things occur abroad, the taxpayer has to provide all relevant information. Often they don't. That's another point. For cross-border cases, there are again elaborated instructions on the required records. What we do not know whether these records are true and complete. And again, the tax code has entitled the Federal Ministry of Finance to regulate details on the records required. And of course, they did. Of course, we do not know whether these records always present all facts. I doubt it. The jurisprudence of the Federal Fiscal Court in Germany in this matter quite strictly follows the wording of rules. Now, let me give you two small examples. The first, the correction of income is not limited to prices. We mostly talk about prices, but that's only a part of it. Correction of income because of non-compliance with the arm's length principle may extend to all other accounting measures influencing the income. Another example, there was a judgment concerning profit shifting. Superficially, one might think that the correction of income only takes place if the agreed condition reduces the German income, of course, and at the same time increases the income abroad. This is wrong. The foreign tax law only requires the reduction of the taxpayer's income due to conditions not meeting the arm's length principle. The rule does not require a rise of the taxpayer's income anywhere else. That means practically, we do not have to check foreign taxation. Last point, very important, especially important for the future of Ukraine. And this is a view beyond national law, and I do not only mean OECD rules. We often have to look to European law. It's really often, and it is often quite a difficult task. The Treaty on the Functioning of the European Union knows the so-called freedom of establishment. In general, restrictions on the freedom of establishment of nationals of a member state in the territory of another member state are prohibited. That's the sense of the European Union. If the cross-border business takes place within the European Union, it is a restriction on the freedom of establishment if we correct the income because of a failure of the arm's length principle. Because if exactly the same business had taken place within Germany only, there would be no correction of income. But according to the jurisprudence of the Court of Justice of the European Union, restrictions are permitted under very strict conditions. Roughly, they are allowed for commercial reasons resulting from the status as a shareholder of a non-resident company. But our courts, of course, have to check and consider this. And this European requirement is not just a formality. Quite recently, the Federal Constitutional Court in Germany has overturned a judgment of the Federal Fiscal Court exactly because they said the Federal Fiscal Court had not properly implemented the legal opinion of the European Court. The case was remitted to the Federal Fiscal Court for a new decision. Well, this should not happen, but of course it happens. In the draft I submitted before this conference, I still told the case
5 minutes.
Still pending. But meanwhile, it is decided again. But in fact, without very much of a knowledge gain, the Federal Fiscal Court did not answer the question whether correction of income complies with European law, and why not. The colleagues found that the facts were not sufficient to decide whether, according to the standards of our foreign tax law, the correction should take place at all, whether the treaty complied with the arm's length principle or not. And this was logical. Only if the foreign tax law demands a correction, the compliance of the foreign tax law with European law is decisive for the decision of the court. Otherwise, we do not have to discuss it. So no solution of the problem at this very moment. So far, I just heard the running of time. It was a very tiny glimpse on the matter. I think scientists, lawyers, or a tax advisor can devote quite a professional life to the whole matter. After all, dear colleagues, thank you for listening. I hope for another opportunity for all of us to discuss tax matters, other legal matters. And I very much hope this will take place the next time offline in Kiev. Thank you.
Дякуємо, пані Роберто, за
Thank you for your presentation of the judge's position on the functionalities of courts, and can see in the comments that I received, they are very thankful for the way in which you arrange the emphases of this. This is the offline regime, and that is still available, and on numerous occasions again we'll be able to exchange our experience and learn from yours. So thank you very much. And now, dear colleagues, I'd like to switch to another speaker that I had the honor to be a student of this professor's, and I would like to say that our next speaker, Professor Kispenrad, was with us from the very first moment of this terrible war. He is always with us. He's always there for us. And as the Netherlands and their government and professor and speaker, head of the International Tax Center of Leiden in the Netherlands, the president of the European Association of Tax Law Professors in 2012, and Professor Hetmantsev is head of the committee who presents the committee. Ispenrad is the Mitchell Carroll Prize jury, awarding jury. So we would like to listen to his presentation, it's a pre-recorded message. Unfortunately, he's having a surgery and cannot join us in person, but regardless of the corrections that we have to face, he illustrates just how important it was for him to address us discussing the issues important for the international tax lawyers. He has this statement that there are never boring times for the international tax lawyer. And now we have his professor's presentation, April 2022. The typical model convention or universal convention renewal, the chosen aspects.
Sure. This is case of the International Tax Center in Leiden, in Holland. In the first place, I want to congratulate you with your discipline and with the devotion to your work to organize this important conference in these exceptional times in which you are so cruelly exposed to the Russian aggression. Almost all Dutch citizens have opened their hearts, and many of them have opened their homes to the people of Ukraine. I had the privilege of visiting your country in the fall of 2019. In that period, ITC Leiden was teaching a 3-week course on international tax law in Kiev. And although I'm not back now in your country, I'm very grateful for the opportunity granted to me by Natalia Paziska to speak to you briefly today. Only briefly, because there are 2 issues. In the first place, I had an accident with my motorcycle a few weeks ago, in which I badly hurt my right foot. So I'm pretty immobile now. So I apologize for not being able to properly dress for this occasion. And secondly, I'm teaching these days pretty much full-time a summer course at the ITC Leiden, also on the 5th of July when you have your conference. So I can only join you through this recorded message. Turning to international tax law. We have witnessed enormous developments over the past few years. Most prominently among these developments are the Pillar 1 and Pillar 2 projects of the OECD G20 Inclusive Framework on BEPS, which is now focusing on these pillars. Both are of enormous significance within the time frame of the past 100 years in which international tax law developed. It's probably in this period one of the most important milestones. And the enormous impact these pillars have on individual countries' tax systems, both on their domestic tax law rules and on the way through these rules that countries will be cooperating very closely, jointly, in the taxation of multinational enterprises. In recent months, the GLOBE rules, and I'm referring to the rules of Pillar 2, the rules and commentary that were released in December and March of this year, they received quite attention. But there was much more going on in the international tax arena, that because of the overwhelming attention that's given to the GLOBE proposals has been underexposed. And one of these underexposed topics is the update of the United Nations Model Tax Convention and Commentary, an update that was released just over 2 months ago at the end of April of this year. Well, over the years, the UN model has taken more and more its own course. And in addition to making changes to existing OECD model provisions, the UN model, in its recent updates, has taken courageous steps in formulating its own new rules, regimes, and policy changes. And I would like to highlight 3 of them. Unfortunately, in my current circumstances, I've not been able to make PowerPoint slides, but I've sent to Natalia PDF versions of the texts of these provisions. In the first place, Article 12b and Article 12a. Well, the latter article, Article 12a, was already introduced in the earlier, that is the 2017 update, but didn't receive at the time the attention it deserved. Well, both of these articles, 12b and Article 12a, fit in the series of the existing articles 10 through 12 on dividends, on interest, and on royalty taxation. The new articles 12a and b, like the old articles 10 through 12, provide for taxation by the other state, the source state, of payments. Well, that's gross amount of income. Income is net. It's the revenue minus the related expenses. Well, the articles 10 through 12b now of the UN model provide for taxation not of net income, but of gross revenue, the payments that are made from one country to the other. The other state, the source state, is permitted to apply a fixed rate, usually through withholding, on these payments. So the gross amount of the income that's being paid from the other state to the recipient in the resident state. Well, the important difference with the existing articles 10 through 12 is that while these latter articles 10 through 12 deal with capital income, Article 12a deals with active income. It covers income from technical services. Well, like Article 12 on royalties, also Article 12a does not provide for a tax rate. The tax rate is left open to the negotiation between the two countries when they are negotiating an actual treaty. Article 12a provides for taxation of income from technical services. And the question is, what is it exactly? Is it a service of a necessarily an engineering nature, or is it perhaps much wider? Well, in the article itself, it is explained that it deals with any service of a managerial, technical, or consultancy nature. Well, it helps a bit to understand the scope, but it's very helpful that a commentary on the provision, section 64 of the proposed commentary on Article 12a of the UN model, explains that the services covered include also legal services, accounting services, services rendered by architects, by medical doctors, by engineers, by dentists. And those are just mentioned as examples. So it has a very wide scope. Very important is to recognize that the provision not only applies to services that are rendered by residents of one country performing the service in the other country. No. They also provide to services which are rendered by a resident of one country in his own residence country for a party in the other country. So, for example, if we would have such a rule in the treaty between Holland and Ukraine, if a Ukraine company would need tax advice from a Dutch company, and the Dutch company provides such advice without having to go through Ukraine. So the advice is sent by email or by whatever digital means to the customer in Ukraine. The payment made by the Ukrainian company to the Dutch advising company will be covered by this tax. So in this way, Article 12a provides for an extremely important exception to the general rule on business income taxation that is provided for by Article 7. Article 7 says, if a company of one country, let's say Holland, carries on business, and that could include, of course, rendering services for a client, a customer in the other country, Ukraine. The other country, Ukraine, may tax if the income from the service is earned through a permanent establishment in Ukraine. And if the Dutch company indeed would have a PE, and if the treaty between Holland and Ukraine would provide for what's another older element of the UN model, would provide such a service through a service PE, then under the Article 7 rules, Ukraine would already be able to tax. But under the 12a rule, there is no need that such a service PE is created in Ukraine. Well, just as a brief side remark, under the UN rule, a service PE in the other country, in Ukraine in my example, would be there if the people rendering the service are spending physically time in Ukraine, a minimum time period, which often is defined as at least 183 days in any 12 months period. So the new rule of Article goes way beyond that by not requiring that the service is rendered in the other country. And therefore its scope is great, it's very wide, has an enormous impact. At the same time, that may also greatly increase hesitations on the side of countries from which services are rendered to enter into treaties with other countries to which typically services are provided to include such a provision. Because again, the provision provides for taxation of the gross amount of the income. It's not taxation like Article 7 provides for of net profits. No, it's taxation on gross revenue. So even if the business of rendering the services in such a particular instance would produce a loss in net income terms, still the tax would be due. But since the income overall could be a loss, the tax levied in the source state in Ukraine, in this example, would not be creditable because there is no income in the residence country on which tax is due, against which the foreign tax can be credited. So it's a very far-reaching provision. And because of its reach, it's subject to great doubt whether many countries from which services are rendered will be willing to include such a provision in their new treaties. As a matter of fact, in a tax treaty policy statement of 2020, the Dutch government indicated its willingness to include such provisions only in respect of treaties with the very poorest of the developing countries. A second provision that I would like to highlight in my brief presentation is Article 12b of the UN model. And Article 12b is included now for the first time in the UN model. Earlier drafts were published in 2020, but now the final text is included in the 2021 update of the UN model. By the way, the update is referred to as the 2021 UN model, but that's the typical practice of the UN, that they release new texts of model and commentary only many months after they officially and internally adopt these changes. So what is called the 2021 UN model and commentary is the text that was not released until, as I said earlier, 2 months ago at the end of April by the UN. So the second provision I would like to discuss briefly is the Article 12b, dealing with income from automated digital services. In this way, it provides for an alternative for the OECD Inclusive Framework Pillar 1 proposal. And it does so in a very different way by simply providing for again, a gross basis withholding tax on particular digital services that are being rendered from one country to another country. And the question, which particular services are being covered? It's helpful that the article itself in paragraph 4 provides a definition which says that such income from digital services includes any payment in consideration provided on the internet or an electronic network requiring minimal human involvement from the service provider. It does not, the rule of paragraph 4 adds, it does not include payments qualifying as technical service fees, as are already covered in Article 12a. Well, in Article 4, in paragraph 4 of this new Article 12b, there is a list of types of income that do qualify as income from automated digital services. And the list includes, I mentioned a few, online advertising services, intermediation platform services, social media services, digital content services, cloud computing services, and a few more. Also, with respect to Article 12b, no rate is provided for. It's left to the countries to negotiate the rate for their particular treaty. Same remark can be made here, whether countries that are cooperating within the inclusive framework Pillar 1 proposals of the OECD G20 are willing, apart from, or perhaps in addition to, the rules as will be completed, hopefully before too long, regarding Pillar 1, to include an article like Article 12b in their treaties. Same issue, it's a gross basis tax that will apply irrespective of whether in net terms any income is effectively earned from the provision of digital services, automated digital services in the other country. I must briefly notice, but cannot really spend any time on the notion of the way taxation may be affected in the other country, because the paragraph 3 of the provision explains that instead of a withholding tax, the taxpayer may request a different tax to be imposed instead. And that's a tax on the profits. That means the net amount of the income. And those profits are defined to be in the amount of, a bit complicated, 30% of the amount resulting from applying the recipient's profitability ratio to the gross annual revenue from automated digital services, because derived from the given treaty country. How that would work and the issues this may produce in the practical application can at this stage only be guessed. Well, let me move on to the third item I would like to discuss briefly with you, and that is to deal with Article 13 on capital gains. Article 13 is a very important article whose importance is often a bit overlooked. And the UN, also in earlier updates, has been providing its own views on capital gains that are realized in respect of particular type of alienation of assets and liabilities. Well, the change that is made in the 2021 UN model update continues an earlier change, and that earlier change provided for a taxing right of the other country in respect of capital gains which are realized through the disposal of shares and similar interests in companies of the given other state. So if we again would take the treaty between Holland and Ukraine, if Ukrainian company, if its shares will be held by a resident of the Netherlands, under the OECD rules, gains realized on the disposal of shares of a company that's a resident of the other country, so a Dutch company holding shares in a Ukrainian company, and Dutch company disposing of these shares under the rules of the OECD model, this gain may be taxed only in the residence country of the person alienating the shares. This would be Holland. No taxing right for the source country. So briefly, capital gains on disposal of shares in the OECD model may be taxed only in the residence country of the person alienating those shares and may not be taxed in the source country. Well, in the earlier provision that the UN model introduced, it was already provided that if my example, the Dutch company is disposing these shares in the Ukrainian company, under Article 5 of the paragraph 5 of Article 13, this may already be taxed by Ukraine. So if this 13.5 of the already existing UN model for many years would have been included in the Dutch-Ukrainian treaty, the gain affected by the Dutch company in selling the share interest in the Ukrainian company might be taxed by Ukraine. What's done now is a further step, and we call this taxing offshore indirect transfers. And what does this deal with? And now I refer to the print. I've sent a print that shows two diagrams. In the first diagram, you see in state S, let's say that is Ukraine. You see this yellow circle with the S, well, that's the source. Let's say that's the Ukrainian company, and Ukrainian company shares are held by company R1, which is a company resident of the other country, and let's assume that is Holland. So this first picture, the situation that we see there, is covered by the already existing rule that, different from the OECD model, state S, in my example, Ukraine, may tax that gain. Well, let's move now to the second picture. And there we see that the Dutch company is R1, is being held by another company in a third country, and it's company R2. So if rather than company R1 selling the shares in company S, and again, that was already covered by the existing Article 13.5. If we have now company R2 that sells the shares in R1, there is no direct sale involved of the shares of company S. No, it's an indirect share transfer. So in such a case, the gain that R2 will realize by selling the shares of R1, and if R1 only holds the shares in company S, then the value of R1 will be very much determined by the value of S. So R2, by selling the shares of R1, will indirectly realize any increase in value of company S. Well, under the new rule, which is introduced now in the 2021 UN model, Article 13, paragraph 7, is that state S, the yellow state, may also tax that gain that company R2 realizes by selling R1. In a way, it makes sense. In another way, it creates a huge problem. Because if indeed state S is going to tax the gain that has been realized by R2 in selling its share interest in R1, and after that sale, a year later, R2 in its turn would sell these shares of company S under the R1 S treaty. The rule of Article 13.5, direct transfer of shares, state S will be unable to tax that gain, that is the gain realized by company R1 on the disposition of the shares in S also. So whereas the earlier gain realized by R2 in selling the R1 shares does not involve, of course, directly the underlying S shares. It does deal economically with the very same gain that's going to be taxed a year later when R1 is going to sell its shares in company S. So let me repeat. The first disposal takes place under the R2 S treaty. The new provision of Article 13.7 in such a treaty would allow state S to tax the gain that R2 realizes in selling the R1 shares. If a year later, company R1 is going to sell its direct share interest in S, under the R1 S treaty, Article 13.5, S will be able to tax also that gain. But that second gain is economically reflecting the same gain in the value of S as was taxed earlier. So the new rule introduced now through Article 13.5 is fully understandable, but at the same time, it creates serious instances of economic double taxation that cannot be released easily. It's a huge and fascinating and very complicated issue. And I guess that the inclusion by the UN of this new rule in the 2021 model will give rise to a lot of discussion. On the one hand, what is fair in granting taxing right to source countries, and on the other hand, what is fair in obtaining, reaching, and realizing the objective of avoiding double tax. Not only juridical double tax, that is, the same income is taxed twice to the same taxpayer, but also economic double taxation, where the same gain is taxed twice, not to the same taxpayer, but to different taxpayers. And in the example we just discussed, those taxpayers would be R2 and R1. Well, I'm afraid this is going to be the end of my presentation. I wish you all the best with the continuation of your conference. And of course, I wish you continuing courage and success in the war you are fighting. I hope and trust I will be able to visit your country and you particularly again before too long. Bye for now.
Ми теж всі
We'd
очікуємо.
like also to express our hopes for the victory as soon as possible. Like again, we would like to thank Professor von Rad, and we would like to see you in Kiev. In his presentation, Professor was referring to the table, and this matrix will be provided for you. We cannot, for technical reasons, share it now. But on our own behalf, I would like to say that we are having this surgery, which is urgent with Professor Van Rad, and we would like him to be able to share his knowledge, his wealth of experience with us, and for all of us to serve as a model in our case law. In Ukraine here, and this is an attainable goal in my book. Now I have the great honor to present our next speaker, who is a judge, doctor of legal science, doctor of law. Igor Olander is his name. His decisions are read by everyone. They serve as model decisions. They are fundamental. So today is a great honor for us to listen to Judge Olander's presentation as to how to avoid double taxation, the essence and the case law of the Supreme Court. Thank you very much, Natalia. Thank you for this generous introduction, for your warm words. This is mutual. I would like to greet all the participants of this conference without any doubt. My predecessors were very exciting in their discussion, and my presentation has to do with avoiding double taxation. The essence of this notion, as I understand it, in my capacity as a judge, I would like to use two cases specifically, not to overload you with information and trespass on your time unduly. I would like to focus on the two cases, which are very representative in my view. Now, to avoid double taxation, we have to discuss this issue, not because of the good news, but the bad developments in our country, the unprovoked aggression, the war waged by the Russian Federation against us. Let me tell you more. This is related, in my personal opinion. I'm not airing that as any official statement. It is too early to come up with a final judgment, so to speak. It should be adjudicated in the future, but this is related to the fact that many residents of Ukraine, natural persons and legal entities, individuals and companies have to seek temporary or permanent refuge abroad because of this war. But all things in due course. Now I have broken down my presentation to several blocks, the background, the essence, and the case law. Just a little bit. So next slide, please. Thank you very much. In modern conditions, economic activities of our business agents are not confined to boundaries of one state, and the taxation is regulated usually nationally. Double taxation that can be produced because of the discrepancies presents a considerable problem for economic activities and also normal function of the already existing business. Especially true this is when it comes to proper regulation of the double taxation issues, because the basis for this is the jurisdiction issue for the country of residence of a taxpayer and the source country, the country where the taxpayer has some gain, and when both countries apply their authority for taxation purposes, we can, and as a rule, we observe double taxation, the double tax burden. Let me tell you more about the background. You can see it in this slide. This problem, solving this problem, we had such attempts back in the 19th century. Back then already, some continental law states were trying to sign bilateral agreements to avoid that. Then there was an interval for some time. Let's say we know very little about some period, but in the 20s of the 20th century, the renewal of international economic activities, we can see more of this, and the League of Nations was taking efforts to approach this problem, to solve it, and they created a task force that would approach this competently and try to look for some solutions. But here we have to mention, next slide please, that it was only in the 60s of the same century that the outline of the solution began to be seen on the horizon to avoid double taxation, taxation internationally, and that was because of OECD, Organization of Economic Cooperation and Development, which activated their platform some actions for development and adoption of the Model Convention, for creation of some stimuli or incentives to amend that and streamline this and amend the national legislation consequently for the countries of Europe in particular. I'd like to say that the result of such activity and the Model Convention coming from OECD was the considerable raise of bilateral agreements, number to avoid double taxation between two states. We understand that the countries are not obliged to comply but in those bilateral agreements, but at the same time they concluded more than 2,000 agreements. Next slide please. So more than 2,000 agreements, and that procedure, let me tell you, was confined to the situation when there were some contractual arrangements for the Model Convention under them, but they would adjust only some provisions of the said convention of OSCEs to the needs of their contracts, so avoiding double taxation in modern legal and economic conditions. So that's part and parcel of economic relations and foreign policy. Because of norms of the international tax agreements, there is more clarity and certainty in fiscal regimes of the said countries, and the exchange of information, mutual assistance, so that in the future we can have some impact on deterring activities aimed at tax evasion, and also providing for the new opportunities to develop international trade and provide for FDIs. So practically speaking, the most important principle now is goodwill, and so for interpretation of the good faith to avoid double taxation for all the countries which do not provide otherwise. They should uniformly apply the interpretation coming from the comments to the model OECD convention. So in the version that was effective at the point of conclusion of a contract. So our next slide, please. Well, coming to the reasons for double taxation, we can say confidently that this is not a unique way to avoid double taxation. There is an option, the option of unilateral acts issued by a state. But from that point of view, from the viewpoint of such country, usually there's emerging economies and they set the price, attach this price to the revenues, tax revenues, to achieve the level of FDIs desired by them or desirable for them. So they stimulate in that way urge investors to comply with such conditions and be attracted by the incentives thus provided by the state in question. At the same time, we have to mention here that double taxation, in my view, and I'm in concert with the majority of the authors on this, had the multinational cross-boundary nature of this. National legislation, any national legislation is small to resolve that. With the EU law, the acquis communautaire, we can see that this taxation crops us not just because of the difference in tax systems of the EU jurisdictions, but also is a negative phenomenon that is characterized with such essential issues, by such essential issues. Well, if we try to describe double taxation and the reasons for its appearance, we can say that it can be approached differently. One of the avenues is a differentiation between economic and legal aspect of double taxation. Let me refrain from discussing it any deeper, but you can see the economic definition. Next slide, please, because just a couple minutes left. I do not want to trespass on your time unduly with my presentation. Let's scroll down and down. Next slide, please. Well, avoiding double taxation is achieved with different tools. This is about concessions and fiscal interest for at least one jurisdiction. This should be true to avoid double taxation. There should be mutual governmental interests, like for Ukraine. This is the tax paid abroad, Article 13 of the Tax Code of Ukraine, the provision on including the incomes obtained abroad, the amount of the taxes paid abroad also should be taken into account according to this article. Let's scroll down further. This is the essential content of double taxation and avoiding it. So I'd like to tell you that in the Ukrainian legislation, the tax code they apply the avoiding or removal of the double taxation. That means that this rule is set for good faith taxpayers. For the rest, we can use evasion, tax evasion, and I think that this is for removal or exclusion, but not providing any ways for tax evasions at the same time. Wait. So, sorry, this is the sources. This article 154. Sorry, and this I'm not. I'm now switching to the case law of the Supreme Court, and let me concentrate on the two cases, just two cases. Next slide, please. We're talking here about the jurisprudence of the Supreme Court of the 29th of September 2021, 640, 10, 635, 20. And another case applying a criteria for presence of an foreign organization, this state, providing for the obligation to pay the taxes established.
Такі основні критерії, тобто наявність місця ведення підприємницької діяльності на території іноземної держави, тобто об'єкта або обладнання, де така діяльність ведеться, місце ведення підприємницької діяльності, що він має характер стабільності і стаціонарності, тобто має розташовуватись в певному місці і з певним ступенем сталості. І третє підприємство...
So it has to be with some degree of stability, and the staff or others act only where this activity is carried out. So, in this regard, there are points that the court took into account when considering the case and what is necessary and important to be taken into account. The 5 paragraphs that I will not be going through, they are similar to the comments and to the practice both of an international law and for the European Court, although we do not rely on it, but it is somewhat close to the things taken into account by our European colleagues. So we'll go to the next one now. Here we have to apply the principle of international taxation and standards of accounting as essence over form or content over form. We know it very well. This doctrine has been developing for a very long time. I will not cover that too. Also, let me tell you that what we covered already, that there are issues covered by the Supreme Court about double taxation and other ones. Overly interesting one, it had to do with beneficiary and the one gaining income. And here, an interesting practice in view of application of Article 103 of the Tax Code of Ukraine. And now we go further. So here, they were mentioned and there were conclusions made about what is the correlation with our tax legislation and the comments to the article 11 and 12. And also there was a conclusion made that neither the convention or other does not cover the notion of beneficiary owner other than dividends and percent. And for this end, the commentary says that the beneficiary owner is related to specific wording used in Article 11 and 12 of the Model Convention, that is, the use payable by for the resident country. Another slide, please. So here, the Supreme Court made a decision that the concept of beneficiary owner from any other provisions does not meet the requirements of the legislation, but the conclusion made gives rise to any payments done in favor of nominal holder or nominal owner. And you can find the resolution on your own and look it through. I want to make some brief conclusions that elimination of double taxation is impossible only by amending national legislation. There is no consensus on the best principle of eliminating double taxation, and the only one mechanism or regime for its introduction. And 2 points that were most interesting and that came up when considering such category of cases by the Supreme Court. Those were the cases related to choosing due taxation regime and the use of the beneficiary owner concept. Thank you, dear colleagues. I'm sorry for going a little bit beyond my time frame. Again, sorry. I wanted, of course, to say that in this shortage of time, I'm very thankful to everyone. Natalia, too. Thank you. Thank you, dear Mr. Ihor, as brilliant coverage of the challenges and for a thorough account of the reasons for double taxation arising. And we see right now why in this address there is a use of eliminating of double taxation. But the next speakers, it will be sort of a duo that will be done by Vitaly Smerdov and Dmytro Mikhailenko. Mr. Vitaly is the head of civic society organization, the Tax Chamber of Ukraine, and we have also here with us head of the Industry Chamber of Ukraine, and that is already very important in terms of avoidance. That is, the next topic is the use of the Convention on avoiding double taxation, the rule of constructive dividends exemplified by the practice of national courts, and there will also be international experience presented. So, dear Vitaly, Dmytro, the floor is yours. Thank you for your introduction, dear Natalia. Now I will try to launch my presentation. I hope you can see it well. And here I am launching it in a way that will be good for everyone to see. So, dear colleagues, I hope you can hear and see me. We, Dmytro and I, wanted to emphasize a couple of points that are related to the application of the Convention about avoiding double taxation. And also in practice, we have, in terms of tax checks, that from time to time, or gradually, I should say, find themselves in tax court and case law, case activities and case law. Some of them will be very important in view of tax residence of persons who have temporarily left the territory of Ukraine, but it has to do with the avoidance of double taxation. Also, please be mindful that Metro and I are, first of all, academia members. We're not judges, we're tax advisors. We practice tax every day with requests from the business, in particular legal persons, individuals, and also from requests that have to do with the application of the Convention on Avoiding Double Taxation by Tax Authorities. So the first issue has to do with the certificates on avoiding double taxation. It seems to be an easy question. So you have a certificate of a resident, and in case of course, it's in practice, we like say the resident certificate and non-resident certificate, but we have this long name, 03.4, the certificate confirming that a non-resident is a resident of a country with which another country has entered into a respective point. I am now with a video, and if there will be if there is bad connection, I will stop my video because I'm now in Irpin. Irpin has suffered a lot, and that's why connection is not always stable. So there is the certificate, and that's it. So what can be difficult? But almost every half a year, we have some new cases in terms of applying this certificate. And now, after the war broke out, we saw that the tax service has extra conditions in terms of the way how the reference this is structured, unlike local legislation of a specific country puts it. So, look, when a company, a legal entity in Ukraine, gets pays some profits to the non-residents like royalties or other types that is subject to non-residents taxation. And in order to apply the provisions of the Convention on Avoiding the Double Taxation, it's necessary to get that certificate. Okay, so we get the certificate, we apply the convention, but here the tax service comes and the tax service puts extra requirements about the type of the certificate. And these issues, unfortunately, we have seen in many instances, not only separate ones. After the war, we faced the requirements and we had the convention with France about this extra requirements for the residents certificate. So from the standpoint of the tax service, there is Article 29 of the Convention on Avoiding the Double Taxation with France, the way of application of the convention. And the part 2 of this convention mentions that in order to get gains provided by Article 10, 11, and 12, the residents have, unless otherwise settled by patent bodies, should provide for the residents permit that has respective amount of the income. And we had this practice from the tax service. France does not give a certificate that contains the amount of the income. And the tax service considers that this certificate does not meet the convention, does not meet Article 29 of the convention between Ukraine and France, and mentions that on that account, when taxes are not collected on such dividends, there are no grounds for that, actually. That is the position of the tax authority, and here Dmitro and I would like to emphasize that this is a way of applying convention. It is not right. So it is not the position of the judiciary so far, it is the position of the tax service. Why is it faulty? In our opinion, it is faulty because, first of all, we see how the basic rule is formed. We get the certificate is issued by respective competent authority according to the legislation of respective country. So the form of the certificate is approved and is determined by the legislation of a respective country. That is the first point. Another point, even if, let's say, even if we read the convention and we see this requirement about the nature and amount of income that should be there, but the convention itself does not determine the way of lifting the double taxation. And it was also mentioned in a couple of decisions by the Supreme Court. In particular, decision of 2019, we see that the convention does not set forth the rules for taxation, the list of taxes and their taxpayers, the way of administering rights and obligations of the parties. It is quite important. And also decisions of the Supreme Court as of 2021, also the tax service demanded or required that the certificate didn't have the reference to the convention between Ukraine and Cyprus. And in opinion of the tax service, this certificate was also faulty, and the Supreme Court also said that there can be no extra requirements to a certificate as compared to the ones determined by the tax code of Ukraine. So this is the comprehensive analysis of the forms. It should be issued according to the requirements of a respective country. It is what is mentioned in point 103.5. Moreover, the convention itself between Ukraine and France, as we see, Article 29 being referred to by the tax service, it is stated in the article, unless otherwise provided by respective authorities. So, if we have no other form of the authority with reference of the given income, that is reference of the tax service to the faulty nature of such certificates, they are without any grounds. But on my part, I want to say that is not an element of the case law. It is just the element of the practice of the authority in charge of taxes. That is a brief comment about the first issue about the certificate, and also another two comments on the viewpoint of practice. I didn't even look into it, so I didn't even make any references. First thing, please be mindful of the fact that during your practice, indeed, there are certificates that the forms of which are set forth in respective legislation of the country and that are not typical. For example, there are certificates that contain references to the type of income. So they do not cover all the incomes of the non-residents, but they just cover only the income, such as royalties, dividends, or interest. Please be mindful of the fact that there exist such certificates. In particular, Germany issues such certificates, as far as I remember it right. We have this practice, and also about the date when the taxpayer should get that certificate. I remember that there is a Supreme Court judgments that say that the certificate must be got or received after the income was paid to the non-resident. But also there is a position that the certificate must be there from the non-resident at the moment when the income is being paid. So there should be legal certainty, there should be understanding of whether there will be use of convention on avoiding the double taxation or no. And the certificate itself is valid for a year, irrespective of the time where it was issued, up to the payment of the income. So, Metro, I understand that I went over time. On my part, maybe
Тобі стосовно MLI, якщо ні, тоді я продовжу стосовно резидентства. Дмитро, скажи, ти тут?
Я вважаю, що визначення податкового резидентства – це найважливіше питання, і ми маємо підтримати попередню доповідь судді Олендера, тому що наразі це навіть не суто українське питання, це буде розглядатися між податковими органами і судовими інстанціями різних країн, де вони будуть оцінювати критерії місця постійного.
The criteria for the vital interest center, and in our opinion, the principal criteria for the model convention and any bilateral conventions for that matter. At this point, Ukrainians migrated 7 million, about 20 jurisdictions we're talking about here. And the residency already, the criteria for 183 days and more than 183. That's a very simplified view. This is streamlined for the inspection, but I can see the third criteria for the tax residency as a notion, which is of less importance than the domicile and center of vital interests, life interests. So we offer for the Ukrainian citizens who would like to maintain and retain Ukrainian residency, even using this temporary protection regime, staying abroad, but willing to pay taxes to the Ukrainian budget, not the Polish, Estonian, and any other one, the worldwide income. And here's some set of arguments. Even our homes in Ukraine, we want to come back to our domicile. And another argument, men have to stay in Ukraine to defend their country, and women and children go abroad. And because this is a family, we cannot say that a wife staying in Poland or Switzerland as the center of vital interests in that other country, while her husband is defending the country, cannot leave it anyway. So this is all based on the bilateral model convention. Even in this case, when we master the fiscal bodies of foreign jurisdictions will try to tax everything based on their national legislation. And this does not go to the Ukrainian budget. It's much higher than the Ukrainian legislation is providing for, as far as our citizens are concerned. We analyzed the jurisprudence. There were some decisions for the fact to be established, whether you're a resident of this or any other state. Based on such solutions, we decided that they were more well thought of, well crafted, deliberated, based on the facts that there is this domicile center of vital interests where people stay mostly, even paying the utility bills. You can see that in the screen, I believe. Great, it's a great example. In Bulgaria, she's thin and she has her domicile in the Ukrainian state. but that person created a company, got employed, and that was a man, and brought his interests with him in, and he's a tax resident of Bulgaria. This is just a case study from the case law, but our Ministry of Finance are trying to talk to OECD and tax authorities of other countries, providing them with the arguments thanks to which our citizens still stay tax residents of Ukraine. This is another way to solve a potential conflict. We can not cross it out, delete it, but strike it out. But I think this is an effective alternative if fiscal bodies, tax authorities of other countries can agree with us, or OECD would uphold the position of our Ministry of Finance. Thank you very much, Dmitro and Vitaly, for the discussion of such topical issues. And for the future, we will have meetings for the judicial community. It is very important for the judiciary. So using my capacity as moderator of this discussion, I'd like to ask Vitaly, you were talking about this reference. How could the official avoid the criticism from you, the institution, the tax authority, you mean, right? Well, the official body. Now, in fact, with Mitro, we always come from the reference point that the tax authority is not our opponent. We are looking for truth here, and the truth is in correct application of the double taxation treaties, and this taxation in particular. When the application is correct, it is only possible, well, it is possible not just with the literal reading, the letter of this convention, but it is necessary by all means read the commentaries, the model convention or OECD convention, because they serve as an official source of interpretation and the reference base. In one way or another, this is reflected in either commentaries or jurisprudence at the level of the first or appeal instance. The Supreme Court in our case, so when the institutions and they rigorously apply the law and judicial system, the status of judges, this is necessary for the tax authority in particular as such an institution. We have to explain to the inspectors and inspecting parties that this reference can be used. Otherwise, we can face this very difficult situation when a holding company getting dividends in France, they fail to understand why Ukraine wouldn't agree to the form of reference that was issued by an official institution in competent body in France. And this leads to some misunderstandings and misinterpretations. These does not provide for any kind of consensus. Well, that's my recommendation anyway. Thank you very much, Metro. I hope that after this conference, all of us will be able to look into a presentation again to revisit it. So, well, we are very much interested in the petitioner's opinion. We can use one to form the stance of the judiciary and individual judges specifically. Now I have this great delight to invite a professor. It's a dream actually for any international tax lawyer to listen to his lectures. If you aspire to have some success, now Professor Brian Arnold, Senior Advisor to Harvard University, visiting professor. We have to say good morning to you, Professor, because of the time lag, and it's about 4 or 5 a.m. Can imagine that. Professor Brian, can you hear us?
Yes, I can.
Thank you, dear professor. І сьогодні професор Брайан виступить на тему зміни.
Professor Brian J. Arnold, Senior Advisor, Canadian Tax Foundation, will discuss changing the structure of the international tax system, the two-pillar solution. Professor Arnold, the audience is all yours. Thank you for supporting Ukraine at this hour.
Well, I'm very pleased and honored to be speaking with you today about the proposed changes to the international tax system. But I must admit that I feel helpless and inadequate in doing so because you're fighting for your very survival right now. And you're fighting against an evil force that does not adhere to any civilized values. All I can say to you is that I wish my own country and all Western nations would do more to help you in your struggle. And I wish that my fellow citizens would stop whining about the price of gas and just, that's a small price to pay to support you. So what I'm going to talk about this morning is the current proposals made by the OECD inclusive framework for changing the structure of international tax. But in doing so, I want to put those proposals in the context of our existing international tax system so that at the end, you can make an assessment about how significant these proposed changes are. Now, I don't have a lot of time, so I'm going to have to paint with a fairly broad brush. These fundamental principles of our existing tax system were established back in the 1920s by the League of Nations, followed up by the predecessor to the OECD. And the primary concern that they were addressing was the potential for double taxation. So what they did was they established the basic principle that the country where income is earned, the source country, should have the first right to tax that income, which I think makes a lot of intuitive sense to us. And the country where the taxpayer is resident also has the right to tax that resident on its worldwide income, including the income that it earns outside the country in which it's resident. Right? But that country, in order to relieve the double taxation of the income, has to provide relief for the foreign taxes imposed by the source country. That principle, that the source country has the first right to tax, but the residence country also has the right to tax, but a corresponding obligation to relieve double taxation. And then what the League of Nations suggested was the source country's tax rights should be limited to a threshold. So only if a non-resident establishes a subsidiary in the source country, which would be a resident taxpayer in the source country, or if it establishes a permanent establishment there, can it tax a non-resident on its business profits. And of course, we all know that a permanent establishment is a fixed place of business, because that's how business was done back in the 1920s and 30s. Or there's a dependent agent with authority to conclude contracts. The other fundamental principle that was established early on was that the profits of a multinational group of companies should be allocated amongst the members of the group using the arm's length standard. So basically what they decided was, we should play let's pretend. Let's pretend that the members of a multinational group deal with one another at arm's length, when we all know that they don't. They're part of an integrated enterprise. So those fundamental principles underlie our existing international tax system. And of course, those principles made it relatively easy for multinational enterprises to avoid tax. Right? So for example, you could avoid tax in a source country by not having a permanent establishment there. And of course, we understand today that the ability for large tech companies to provide digital goods and services means that they don't have to have any presence in the source country to earn income there. Now, the pressures on this existing system have been there from the beginning, because of the fact that it was so easy for multinationals to avoid paying tax. And what I often like to use as a metaphor to describe the situation under the existing tax system is a football metaphor. So I'm sure that all of you have seen 6- and 7-year-old children play football. And when the ball goes over here, you have this whole bunch of kids who chase after the ball and crowd around it. And after a while, the ball pops out over here and they all chase the ball over here, right? And you've also watched professional football teams with their disciplined positional play. Well, the metaphor is that the professional football side is the multinational corporations. And the 6- and 7-year-old children are the tax authorities of the world. And so while the tax authorities of the world are running around chasing the ball, the money, right, it's already gone somewhere else. The multinational has already moved it somewhere else. Right? Now that's an exaggeration, but it's not much of an exaggeration, because multinational enterprises can establish controlled foreign corporations in tax havens. And what does that mean? Well, it basically means that they're not subject to tax by the residence country. And then they can use the tax haven entity to earn income from a source country without establishing any permanent establishment there, which means there's no source country tax. What's the result? They don't pay tax anywhere. And obviously that is unacceptable to most countries. So what we had is a bunch of responses, and this started back in the late 1990s with the OECD harmful tax competition project. But countries started to respond to this. And what did they do? Well, you can see on the slide there, I'm not going to go through them all, but you can see the various approaches that countries took. And especially a number of countries started to adopt digital services taxes. So they'd impose withholding taxes on payments for digital goods and services. But there were a bunch of other proposals as well. The international community, the OECD, became very concerned about these proposals because they represented a patchwork of international responses and increased the likelihood of international double taxation. Okay. And so what did we see? Well, we saw the international community respond by launching the BEPS project. And the BEPS project accomplished some things, but was largely ineffective with respect to taxing the digital economy. Okay. And so what happened in 2019, the OECD, through the inclusive framework, made these proposals for Pillar 1 and Pillar 2. I should also note that the United Nations has been working on these issues as well. And in 2021, added a new provision, Article 12B, allowing source countries to tax income from automated digital services. The problem with that, of course, is that we all know that developed countries are not going to enter into treaties that contain Article 12B. So it just does not really address the problem. So what the focus of the rest of my talk will be just a very brief overview of Pillars 1 and 2 so that we can understand just how significant these proposals are. So Pillar 1 is an attempt to get the largest and most profitable companies in the world. So this is a provision that is of limited application. And the OECD itself has indicated that there are only about 100 companies that are going to be subject to this, this new Pillar 1 regime. So you can see there that it's global turnover of 20 billion euros or more, and a profit ratio of 10% or more. It's not going to apply to extractive industries and regulated financial businesses. Why not? Because those are businesses that countries can tax because they have to have a presence in the source country. Important to understand that this is not limited to just the big tech companies that provide digital goods and services. This applies to all companies. And what's going to happen is that the source countries, the market countries, are going to get a new taxing right. So they're going to get the right to impose tax on the residual profits earned by these large multinational corporations. And the residual profits, it's referred to unimaginatively as Amount A, is 25% of global accounting profits in excess of 10% of gross revenue. And those profits are going to be allocated to the source countries based on the sales revenue derived from those countries. So you can see, I think, right away, one of the really important aspects of Pillar 1 is it's abandoning the arm's length transfer pricing approach that has proved to be ineffective. So this is going to be a shift to allocating profits on the basis of a formula apportionment approach. So it is dramatically different, even though it's restricted to those 100 largest countries. The other aspects of Pillar 1, and this is, of course, coming from the United States, they've basically demanded that countries must eliminate their digital services taxes and any similar measures. So that's a condition for going ahead with Pillar 1. These rules are going to be very complex because they involve changes to domestic law, changes to tax treaties. There's going to be a multilateral agreement to implement this. And if Ukraine is thinking that it's going to raise a lot of revenue from this, I'd say don't don't spend it before you know you're going to be getting it, because it's just a bit uncertain what the revenue implications actually are. Pillar 2, just briefly, this is a minimum tax, a global minimum tax on large MNEs, global revenue in excess of 750 million euros in 2 of the previous 4 years. So this is similar to the country by country threshold. And what's going to happen under Pillar 2 is there is going to be a tax imposed, a minimum tax, to the extent that the income earned by a multinational in a foreign country is subject to tax there at less than an effective tax rate of 15%. So the country where the parent company is resident is going to be able to impose a tax. It's a top-up tax. The top-up will be the difference between 15% and the source country tax. And that will be supplemented by some other minimum taxes as well. Now, because I don't have much time, I won't get into the detail of the minimum tax, but you should know it's going to be levied on excess profit, which is net accounting income earned in a country less a special exclusion. And that exclusion is described briefly on the slide there. Right? And that exclusion means that countries can provide tax incentives to the extent of the amount of that income. There is also a special provision. This is called a qualifying domestic minimum top-up tax. This is very important. And I know you haven't asked me for my tax advice, but I'm going to give it to you anyway. Ukraine should adopt a QD-MTT, because this is the way that Ukraine and every other country that's going to do this can avoid giving up tax revenue that they could collect, right, to other countries. Because other countries are going to impose those minimum taxes. The QD-MTT, if you adopt it, is a way that you can avoid allowing other countries to top up your taxes to that 15% level. So let me just say in conclusion that these developments, Pillar 1 and Pillar 2, are, I think, extremely significant. And if they're successful, they will basically make a significant change in the international tax system. It will be a very positive change. I think for most of us, it is unthinkable that we could have a common 15% minimum tax on the income earned by large multinationals, even 10 years ago, when the BEPS project was underway. I think that was just unthinkable. So this, if it happens, will be a remarkable achievement, and it will boost multilateral efforts in the tax area. By the same token, if it fails, right, that will set back multilateral efforts for a long time, but I'm optimistic. I'm optimistic that it will be successful. Thank you very much.
Thank you, dear Honorable Professor Brian. It is we who are thankful to you for such an in-depth coverage of the topic that you have chosen and for the advice that you are giving our country. I hope that the representatives of the legislation and of the executive power will definitely use your comments and advice. Dear colleagues, that is how we, within 3.5 hours, had the honor to hear from most respectable judges, professors, and practicing professionals who deal with transfer pricing. And to finalize this session, I would like to remind you of the words once mentioned by Mr. Smokovich, that there are three branches of power, but the judiciary is a little bit higher than the two other branches of power. A little bit different. It's just higher above them. You see that it's higher above them. Thank you. So, I am very sorry. Yes, so I hope, I am convinced that the caseload that we will be shaping, taking into account these expert opinions and lectures that we have heard today, that will be exemplary for other countries. And I want to thank again, Professor. I understand that it's early morning and you're here with us. And I hope that next year we'll have a chance to welcome you in Ukraine, that finally there will be peace, there will be victory. I am very thankful for the support and for the words that you, from the very first days of the war, have been sending to us. It means a lot. And dear colleagues, to finalize the session, I invite you after the lunch break to have the next final session of this two-day conference that will be moderated by my wonderful colleague, very talented judge and Dr. Habilitas, Irina Zhovtobruch. The topic will have to do with consideration of cases of specific types of cases. I hope it will be as interesting. I'm convinced that it will be very interesting. And I wish us all peace. I thank everyone, all the speakers today, for such interesting and thorough and fundamental approaches that you have presented to us today. I hope that very soon we will celebrate victory. Dear Raisa and dear Mihaila, I'm thankful for a chance to moderate this session because these issues are very interesting for me. I had a chance even to study from Professor Brian last year in Harvard University course, and I hope that we will have a lot of such options. Thank you so much, and we're looking forward to seeing you at next session. Glory to Ukraine.